Welcome to our video series previewing the panels at the 2026 FBA Qui Tam section Qui Tam conference. The theme for the 2026 conference is the FCA in an era of uncertainty. I'm Scott Oswald, Programming Chair of the Federal Bar Association Qui Tam section, and joining me today is Diana Cieslak. She is counsel at Ropes and Gray with a preview of her panel, FCA Liability for Anti-Kickback Statute Violations. Diana, welcome.
Hi, Scott. Thanks for having me.
Boy, this is really a timely topic of interest to all False Claims Act practitioners. Diana, tell us just a little bit about your panel and your speakers.
Happy to, Scott. This panel will explore the still evolving circuit split regarding the causation standard that applies when a False Claims Act case is premised on a violation of the Anti-Kickback Statute. This is currently a very active issue in the FCA space and one that continues to evolve. As I'm sure you know, Scott, in 2010, Congress amended the AKS to state that any claim for payment that includes items or services resulting from an AKS violation constitutes a false claim under the FCA. Courts have been asked to interpret the resulting from language that was added to the statute. And in the past couple of years, a circuit split has widened over how to interpret that language and whether the government must meet a but-for test or a more lenient causation standard. This session will unpack what this causation debate means for FCA cases premised upon violations of the AKS and the practical steps litigants can take to either prove or disprove FCA liability while this split persists. So we hope this panel will be an in-depth exploration of a very active, hotly contested topic in the AKS space, and AKS cases have been and will continue to be a mainstay of FCA practice.
So Diana, my guess is that you and your panel will explore where the circuit split is going in the future. For those who will be tuning in either remotely or in the room, what can they expect to learn?
Well, they can expect to learn how the split evolved. We'll talk about the history that brought us here, the 2018 Third Circuit decision, where the first federal appellate court interpreted the language of that 22 amendment, and all of the decisions that have come since in which courts have grappled with this issue. We'll also talk about how, once that split has opened, litigants have been pressing different arguments regarding how this split should be litigated. As more and more circuits have interpreted the AKS to require the government or relators to establish but-for causation, litigants have returned to pre-amendment theories of liability and have begun once again pursuing false certification theories of liability to establish falsity in these cases. This case will discuss the pros and cons of pursuing either path, and I hope attendees will walk away with a better understanding of the emerging circuit split and how the false certification pathway to liability compares and contrasts with the 2010 amendment pathway.
Diana, thank you. And for those of you tuning in, we look forward to seeing you at the FBA Qui Tam Section's 2026 annual conference, the FCA in an Era of Uncertainty, February 18th through the 20th. 2026. You can register right now at www.quitamconference.com.